So who do I have from MDOC this morning? Mr. Bomarito?
Yes.
Good morning. So
Good
your
morning.
attorney usually goes to the other courtroom first. She'll be with us shortly, okay?
Okay.
All right, thank you.
Thank you.
All right. So Ms. Zuki, your client is now in the Zoom room. So we're ready. In the matter of the people of the state of Michigan versus Matthew Richard Sinclair, we have two files, 25-22245FH and 25-22246FH. This is the date and time set for sentencing in this matter. I have Carly Zilke appearing on behalf of the defendant. What's your P number?
Yes, 79061.
All right. Mr. Sinclair is appearing via Zoom, and I also have joining us Sarah Sinclair. I did receive a victim impact statement from her. Have you received that as well?
I'm not certain I did from Sarah. There was a victim impact statement in 2522246. I believe that I did receive the victim impact statement in that case. And I believe that victim is in the courtroom and planning to make a statement as well.
So, okay, so this, I have it here. So I'm gonna need a copy. Miss Adams, could you come get a copy of this for Miss Silky? Bear with us while we get that, and then if you need a breakout room with your client, you can either go in back or use the hallway. Okay.
Thank you.
All right. So then I do. Are you going to need a breakout room?
I'm not. This is the victim impact statement.
Okay.
I have received.
All right. Do you mind if I take Mr. Mawad, because he's loitering outside of some courthouse somewhere, and I'm sure there's a meaner judge than me waiting for him.
Lovely Monroe County, Judge.
Oh, they're all nice there. So
Yeah, they are.
Mr. Wayne Scott, go ahead and unmute your device and start your audio. Is there anybody here that's a victim in this matter who wishes to speak? Anybody? No? Okay. Mr. Wayne Scott, if you can start your video and unmute your device.
There we go.
Mr. Wayne Scott, can you hear me?
There we go. Yes, ma'am.
Okay. All right. So, great. All right. In the matter of the people of the state of Michigan versus Benjamin Wayne Scott, 24-21932FH and 24-22089FH. Elias Mawad appearing on behalf of Mr. Wayne Scott. I do not appear to have anybody here to make a victim impact statement or a statement to the court. I do have Darren Coast from Pretrial Services. He has provided a letter dated June 26th of 2025. Mr. Wayne Scott is still at Hope House in Jonesville and is doing very well. He appears to be taking the program and his sobriety very seriously. So let me get this. All right, Mr. Wayne Scott, have you had an opportunity to read and review the pre-sentence report?
Yes, ma'am.
Have you had an opportunity to discuss that with your attorney?
Yes, ma'am.
Are you satisfied with Mr. Mawad as your attorney and the advice that he has given you?
Yes, ma'am.
All right, Mr. Mawad, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor. Very accurate, very thorough. Thank you.
Thank you. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defects?
No, Your Honor.
The probation department in this matter computed the sentencing guidelines on 24-21932FH, count 1, breaking and entering a building with intent to be 29 to 57 months, and on file number 24-22089FH, count 1, larceny in a building to be 7 to 23 months in jail. So also, do you agree with that computation of guidelines?
I do, Judge. Yes.
All right, so there is a sentencing agreement, Mr. Wad, that he can receive up to 1 year in jail plus probation and restitution. I don't have Miss Holly, but I do have, Mr. Moore here today. And obviously that was up to 1 year. He's currently in, treatment, so the court will of course take that into consideration. Before the court passes sentence, do you wish to say anything on behalf of your client?
Well, Judge, this was a really good deal struck with Mr. Hartung and I know that Ben knows it. But I want Ben to know that I talked to his father 2 weeks ago. His father was crying. This is his son. He doesn't want him to be an addict. And he doesn't know that I've been talking to his father, but his father's a good guy. And, Ben, during the bond on all this, and even after the deal was cut, he went back to doing it. I just want him to be a stronger person, and I want him to get the treatment, and I want him to take care of his dad. And I hope he does well. He got a hell of a deal here, Judge. And whatever you decide to do is fine. But I want him to know that you got to take care of your dad too. He's at the age now. You got to watch out for him and stay clean. Other than that, Judge, I'm ready for sentencing. The court knows the history of this case.
All right, Mr. Wayne Scott, is there anything you'd like to say on your own behalf?
I'm definitely, it's the first time I've been in rehab, and I'm definitely, I'm mad at myself that it took this long, that it really took all these years to say that I can do this, and I'm excelling. I'm kind of like the group leader here, and I'm taking over all the classes and stuff, and I'm helping all the young guys coming in, and I'm using myself as an example. I'm like, do you want to be like me? Do you want to be 49 years old? Or you guys got a chance. And I've been trying to do everything I can to help out around here as much as possible. And I've been here, I'm clean for 45 days. And that's the first time I've been able to say that in a very long time. I mean, probably 15 years. So I'm here, and I'm definitely I'm gonna make it. I know I'm gonna make it. And I've actually gone to the dentist, and I got my health back on track. My cholesterol's coming down. Everything is starting to work out for me, and that's all I really got to say, Your Honor.
Okay. All right, anything else oh, go ahead, Mr. Wayne Scott. I'm sorry.
Oh, sorry. That was it. I'll start babbling, and then I'll turn into something else. I'm just happy I'm here, and I'm realizing I'm mad at myself that it took this long to get like this. And it wasn't hard getting sober. I'm mad at myself for that. But what's really crazy is I'm learning all these new coping skills and boundaries, and so much to recovery that I never really had a chance before, because I never really thought it was that deep. I'm dealing with a lot of issues. I'm in sessions 8 to 10 hours a day, and I'm learning who I am again. So. That's it, Your Honor. Thank you.
Thank you. Mr. Coast, any other updates from you?
I don't, Judge. I mean, he's doing a great job. I mean, yeah, I commend him on his efforts.
All right, thank you. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. It's a sentence of the court that you will be placed on probation on each file for a period of 36 months. On file number 24-21932FH, I'm going to now listen, 1 year in jail suspended. I'm going to suspend that 1 year in jail, which requires you to complete the program you're in successfully to get out report. If you violate probation, you're looking at a year in jail. Do you understand that?
Yes, ma'am.
On that file, there will be $130 crime victim rights fee. $68 in state costs, a supervision fee of $30 per month, 60 if we need to put a tether on you, and $750 in court costs. I will give you credit for 2 days in the Lenawee County Jail you've already received. So understand this is a downward departure based on a Killebrew agreement that was struck between the prosecutor's office and your attorney. Your guidelines call for a minimum of a 29-month prison term. Do you understand that?
Yes, ma'am.
Okay, and you are 49 years old, so it is time to take responsibility for your life. Now, on file number 24-22089F, I will give you 36 months probation. You have no credit for any time served on that file. There is a $68. Let me see here. Okay, so there's restitution in the amount of $10,700, which I believe is half of the total restoration amount or restitution amount. Is that correct, Mr. Mawad? Yes. So the actual restitution looks like it's $21,400, and you're joint severally liable for that. But your amount is $10,700. So as soon as you get out of rehab, you need to get a couple jobs to start paying on this. On that file, there's $130 crime victim rights fee, $68 in state costs. I already ordered the supervision fee on the other file, so I won't order it on this file. And I already ordered court costs on the other file, so I won't assign those to this file. You are to have no contact with Kelly Moe and or Caitlin Maynor. If she reaches out to you and wants help, direct her to Mr. Mawad. But do not get involved with people who are gonna bring you back down. Do you understand that, Mr. Wayne Scott?
Yes, ma'am.
I realize she may or may not be pregnant with your child. I don't know, but that also means until you have permission of the court, you have no contact with her. Do you understand that?
Yes, ma'am.
Okay, and you must obey and comply with all the articles of your probation, which means no alcohol, no controlled substances, can't be anywhere there's alcohol or controlled substances. You're gonna be required to get a job. Your restitution's pretty high, you better get 2. You're gonna be required to do assessments and treatment. They have the right to search your house and your property if they have reasonable cause to believe you have items which will violate your probation, and any other terms of probation. Now, Mr. Wayne Scott, we'll get an address from Mr. Mawad, but Mr. Moore, because he's in an inpatient program, how do we have him set up to meet with you?
First, I go, what program is he in?
I can't hear you, Mr. Moore.
He's at the Hope House. Tom was asking what program is he in? He's at the Hope House.
And what's it? Do you have an out date, Ben?
Yeah, they're saying it's it was August 8th, I believe, but it's all per how I'm doing. I might actually, they're saying I might leave early. I've completed everything and I'm doing better than everyone else, I guess.
All right, listen up. You will come see Agent Holly upon your release, but if you're released on the weekend, you'll come the following business day. So you also have her number. Make sure that you communicate and sign a release so that they will communicate with her.
Okay.
And then, Mr. Wayne Scott, we're gonna mail to Hope House for each file 3 copies of your notice of right to appellate review. We need you, we'll mark 1 copy for each file for you to initial and date. We need you to initial and date those copies. I'll also send a self-addressed stamped envelope. Put those 2 initial and dated copies into the envelope and mail it back to us. The other 2 copies for each file are for you. If you wish to appeal your sentence, you would fill out the forms and mail them to the address listed on the form within 42 days. If for some reason you haven't received those in the next 30 days, call Mr. Mawad and he'll make sure that we mark that you wish to appeal your sentence. All right?
Absolutely. Thank you.
Okay, those probation terms start now. Make sure you stay in contact with Miss Holly and sign any waivers so she can get information about you there, all right?
Okay, should I call her today then?
Maybe next week. Mr. Moore, call Miss Holly next week.
Yeah, you could call her on Tuesday and give her an update and make sure that she has some counselor's name or somebody she can speak with.
Oh, okay, absolutely.
All right, very good. Anything else, Mr. Mawad?
Well, I just want to let Ben know that, your father's at that age where the kid should be taking care of the parent, not vice versa. So keep doing what you're doing, but also take care of your dad. He literally was crying regarding you. All right. And he's a good dude. Okay.
Yes, sir.
All right. Thank you, Judge. Thank you,
All right,
everybody.
excellent. Thank you.
Okay.
Thank you.
Miss Sophie, now we can. Mr. McCready, on the Matthew Sinclair matter, we do have a victim on Zoom who wishes to speak, so I don't know if the prosecutor or anybody is here for that file. Who is your prosecutor in this?
I believe it was Isaac.
Isaac's name.
Isaac is in the office.
I'm just letting you know there's a victim that's going to speak on that one.
Yeah, I
Okay.
can let him know. Are we ready to do that right now?
Yeah, he can zoom in, it doesn't matter.
Yeah.
All right, so we are back on the record in the matter of the people of the state of Michigan versus Matthew Richard Sinclair. We have two files, 25-22245FH and 25-22246FH. So, Mr. Sinclair, have you had an opportunity to read and review the pre-sentence report?
Yes, Your Honor.
Okay, I'm gonna need you to speak up more so we can hear you. You might be too far away from the microphone, I'm not sure. So can you
Better
repeat
now?
your answer, please?
Yes, Your Honor.
Okay, and have you had an opportunity to discuss the pre-sentence report with your attorney?
Yes, Your Honor.
Are you satisfied with your attorney and the advice that she has given you?
I am, yes.
So Ms. Oki, you've had a chance to discuss the victim impact statement we received?
Yes, Your Honor.
Okay. Ms. Zoki, do you wish to explain or challenge the accuracy or relevancy of anything in the pre-sentence report?
No, not.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
Guidelines do not apply to this case because it was pled down to misdemeanors. So, Ms. Sinclair, it's your choice. You can start your video or you can choose not to. I have had an opportunity to read through the victim impact statement. So if you would like to unmute your device, you can go ahead and make a statement. But again, you don't need to turn your video on if you don't want to. All right, but you can. There you go.
That's fine. Thank you.
All right.
So yeah, in regards to everything, I would really like the no contact order dropped. I want to be able to go to counseling with my husband. I want to be able to be a family. I want to go to church together. I want to be able to rebuild what we had before things went off the rails. Everything that happened was due to substances. That is not who Matt is. He is a great man. He is a wonderful husband and a good father. And I know that he's been going to counseling and I know that he's been working. And I am so proud of how far he's come. And I'm not excusing anything that he did, but I know that he is in a much better place and I want to be able to move forward with him and my family. And I need him home with me and my boys. And I just want to be able to move forward and heal as a family. And I can't do that without him. So I just really want the no contact order dropped, please.
Okay. Isn't May Reed Carpenter your daughter?
She is married.
Okay. I find it interesting that you did not mention one time the emotional damage and trauma he did to your daughter.
Because I'm not talking on her and him. I'm talking on me and him.
Okay.
And the no contact had nothing to do with her and him, this situation.
All right. Are you gonna help him pay restitution to your daughter?
If I need to.
All right. Mr. Sneed, is there anything you'd like to say on behalf of the people?
No, thank you, Your Honor. And I'm sorry, my camera doesn't seem to be working at the moment.
Okay, all right, okay. Anything anybody wants to say?
I guess she's not gonna have to help me.
Hold on, Mr. Sinclair, I'm not talking to you right now. All right, are you Mayreed?
Yeah.
Mareed? Okay, all right, and, so I'm gonna need you to speak loudly because we're recording this, okay? So state your name for me.
My name is Marae Carpenter.
Marie. Okay, go ahead. Say it again, Ms. Faith. Spell your first name.
Mairead.
Okay, very good. So you have a statement you'd like to read, so go ahead.
I personally do not think it is safe for him to be around my mom, me, or my siblings. By him, I mean Matthew Sinclair. From laughing at my infant brother falling off of their bed onto a hardwood floor to punching holes in our walls, doors, and shower, he shows a lack of consideration for others and unrestrained anger, drugs or not. He has directly said to me, verbatim, "I'm scared your mom might push me too far and I'll kill her." I was 17. I implore you to think about the situation and what would make saying this okay. I had no way out of that situation. I had no way out of that home, and I was in high school. I can't shake this feeling that if he is to relapse, if he is to get too angry, and if something doesn't go his way, he will cause potentially irreparable damages. I understand that he is working to improve himself, but this brings no comfort at all considering the situations we have been through previously as a family and both now. I understand that from my perspective, he is the same Matthew Richard Sinclair that stole from me, that hurt my mom, threatened to hurt her, that made me consider suicide. Drugs or not, I have never gotten a single apology, nor has he ever acknowledged his wrongdoing towards me. Bias aside, I think that he needs true consequences and that he has been let off one too many times. Nobody should ever be in this position, in my position at 19 years old. I should be enjoying my summer break before college, but I am here at court fighting for my rights against someone who was supposed to protect me, someone who is supposed to love me and respect me as a parental figure. I understand he accepted a plea deal. I understand that from the plea deal, he will be charged much less than he deserves. And this is heartbreaking to me, not just for myself, but for my community. What happens when another person does something like this? Would you let him loose to continue causing harm to others by allowing him to practically escape from his crimes that he did to his teenage daughter? It's just as poor as he is. I'm disgusted by the blatant disregard to the harm he has done by himself and by my other family members. Just because he admitted to his crimes does not mean he should be punished any less or regarded as any more. Matthew committed unforgivable crimes against me from the ages of 16 to 19. I was in a position to do nothing to protect myself. And if the court cannot protect me, then who should I hope for? And my message to Matthew is as follows. For over the 4 years, you have hurt me beyond words what can describe. And I hope you live the life you deserve, away from me and my family. I would appreciate being paid back, but no amount of money will take away the pain and distress you caused me and still continue to cause me. I might be able to forgive you eventually, but I will never be able to forget you. You will forever be in my nightmares, and I hope that you never contact me again.
Now, have you worked through financial services to clear up your credit score and reports?
Yes, Your Honor.
Okay, so, okay. And you no longer live with your mom, right?
No, I had to move out when I turned 18.
Okay. And you're living somewhere stable now?
Yes.
All right, anything else?
No, ma'am.
Very good, thank you. Mr. Sneed, anything else?
No.
All right, so Ms. Oki, anything you'd like to say on behalf of your client?
Yes, there is, Your Honor, but Mr. Sinclair would like to make a statement, and I would like him to do that first.
Okay, Mr. Sinclair.
Your Honor and to Maraid, the easiest thing I could do today.
We're not picking you up, so you need to kind of face the microphone and speak a little bit louder.
Can you hear me now?
Yes, it's better now.
All right, Your Honor and to Maraid, the easiest thing I could do today would be to stand here and offer excuses, but I'm not here to justify what I did. I'm here to take full responsibility. I accept the consequences of my actions, and I am prepared to see through whatever punishment the court decides. More importantly, I want to speak directly to Mairead, not just my own conscience, but because it's the right thing to do. For years, you trusted me, you confided in me, you welcomed me into your life, even saw me as a part of your family. In some ways, as a father figure, I betrayed that trust. I let you down in the worst possible way, and I hurt you deeply. You are a smart, kind, and beautiful young woman. You are a loving sister to all your brothers, even Matthew and Mason, which you've always treated like they were your own flesh and blood, and they all love and admire you more than you know. I understand that what I took from you wasn't just money. I stole your sense of safety, your peace of mind, and your trust in others. And the hardest truth is no amount of money can fully return what I damaged, and that's something that I have to live with. What I did was selfish, deceitful, and wrong, abusive in a way that words alone can't fully express, and for that I offer my deepest and most sincere apology. I'm not asking for your forgiveness. That would be selfish of me. Whether you forgive me or not is entirely up to you, and I would understand if you never do. But I have a responsibility to own what I did, to make amends where I can, and to clean my side of the street. More than anything, Mairead, I hope that you find healing. I hope the damage I caused doesn't define your future. You have your whole life ahead of you, and I pray that this painful chapter does not shape the decisions or dreams that follow. In closing, I want to say that I believe in you. I believe you are strong enough to build a life you're proud of, one that reflects who you are, not what was done to you. And I really, really hope you believe that too. Thank you for listening.
Thank you. Ms. Silky?
Yes, Your Honor. I would note for the court that Mr. Sinclair did do stay in a rehabilitation facility some time ago. He has been working on his sobriety diligently since 2024. He is currently enrolled in counseling for, I think he did the retail fraud class initially, but is working currently in counseling with Sally Welsh to address both substance abuse issues and anger issues. He is working diligently on that. When we spoke last night regarding the sentencing today, he was working on his homework for those sessions. I think he has taken to heart the harm that he's done and very genuinely is remorseful and wants to do what he can to make amends for that situation. He is fully employed and fully intends to work diligently, making consistent payments to go not only to the court, but more importantly to the restitution. And again, I think just he is taking it very seriously and is looking to move forward in a much better path. We understand that there was an agreement for the 365-day suspended sentence. He fully understands what that means, and that he does not have many chances left, and that is very much hanging over his head with this sentence. So with that, we would request the court impose the sentence as recommended by the probation department.
Anything else? All right, so Mr. Sinclair, parents or parent figures that are supposed to care for and provide for their children, but instead swindle them and take advantage of them are obviously pretty reprehensible. I understand that there were substance abuse issues going on. So I hope, in fact, you do redeem yourself and you do pay restitution in this matter. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon this record on the record at this hearing. Obviously, there's no guidelines. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. It's sent to the court. You'll be placed on probation for a period of 24 months. I will suspend the jail sentence of 1 year in jail per the Killebrew agreement that was reached. I'm going to order restitution on file number 25-22246FH in the amount of $6,000 to be paid and the amount of $250 a month. You are also to, if there are any costs for services to clear her financial record, in case she needs to hire an attorney or pay for a service to help get rid of the debt that you caused her to incur, that will also be added to restitution. I don't know if that'll happen, but if it does, she does deserve reimbursement for that. On file number 25-22245FH, the domestic violence file, I am going to order the 24 months probation. There is a $100 fine, $50 state costs, and $75 crime victim rights fee. I am going to order that I'm going to order a no contact with Miss Carpenter as well as Miss Sinclair. Once Mr. Sinclair has completed his programming with Sally Welsh at Recovery Roads and Miss Sinclair, you can provide proof that you completed a domestic violence victim class. Then you can petition the court to have contact. Miss Sinclair, the hardest thing for me is when I see people walk in the courtroom and choose someone other than their children. And that's what you've done today. And I'm sorry that you were a victim, and I'm sorry things happen to you, but I think that until you and he are in a better place and have received treatment and counseling, that there should be no contact. And like I said, once you've completed those programs, you can request through the probation officer for a contact order. Let's see here. On the domestic violence file, you will complete counseling with Sally Welsh. You will attend 12-step meetings and get a sponsor. You're not to use any alcohol. You're not to use any illegal controlled substances. You're not to engage in any threatening or assaultive behavior. The probation department can search your home for probation purposes at any time, but they also can search your home, your car, your computer, and your personal effects if they have reasonable cause to believe that you have items that violate your terms of probation. If you're in contact with Miss Sinclair, if you are found together, you will do a year in jail. You understand? So on file number 25-22246FH, that's the larceny. That's the file that I ordered the $6,000 in restitution to be paid at the amount of $250 a month, as well as any cost for any services she's required to use to clear her credit report. Let's see. There is a $250 fine, $50 state costs, $750 in court costs, and a $75 crime victim rights fee. And again, the 24 months probation. Same terms of probation will apply. Let's see what else I got in here. I think that's it. Anything else, Mr. Steen?
No, thank you.
Anything else, Ms. Zolke?
No, Your Honor, thank you.
So, Mr. Sinclair, we are going to mail to you 3 copies of your notice of right to appellate review on each file. I need you, there'll be 1 copy that's kind of flagged for you to initial and date for each file. And there'll be a self-addressed stamped envelope. I need you to initial and date those 2 copies, 1 for each file, put them in the envelope, mail them back to me. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail them back to the address listed on the form within 42 days. As a court system, we do believe in redemption. We do believe that people can make change for good, but you know, that's something you're going to have to prove to yourself in the court. And Ms. Sinclair, good luck with the counseling. And once you both have completed it and provided that to Ms. Holly, you can address the issue of whether or not you should have contact. All right, thank you. Thank you. So, Ms. Underwood, I have Mr. Bomarito. He's been hanging out with me this morning, so we'll take care of him next.
Thank you, Your Honor, and thank you
You're
for your
welcome.
patience.
No, I told him you like the other judge better and you go to him first every day, so.
That's, Your Honor, your room wasn't made up, so I went to Judge Oldsaber's room, which was made up, but I did not work first.
Okay, all right, this is in the matter of the people of the state of Michigan versus Delshawn Leonard Bomarito. File number 25-22196FH. This is the date and time set for sentencing. I have Rhonda Underwood appearing on behalf of Mr. Bomarito. Let me find his PSI. No, I have it. There it is. Miss Underwood, I know sometimes it's hard to get into MDOC. Do you need a breakout room with Mr. Bomarito?
I do not, Your Honor.
All right, so Mr. Bomarito, have you had a chance to read and review the pre-sentence report?
Yes, I have.
Good. Have you had an opportunity to discuss that report with Miss Underwood?
Yes, I have.
Are you satisfied with Miss Underwood as your attorney and the advice that she has given you?
Yes, I am.
Good. Miss Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
I don't think so, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
It does not, Your Honor.
The probation department computed the minimum sentencing guidelines to be 10 to 28 months. And of course, the court does agree to sentence him to the low end of the guidelines, which is 10 months.
That's
So
correct, Your Honor, and we have no disagreement with the computation of the guidelines.
Okay. Before the court passes sentence, Mr. Bomarito, do you want to say anything on your own behalf?
No, I do not.
Okay,
Or
Miss
I-
Underwood.
If I,
Oh, go ahead, Mr. Bomarito.
if I could say sorry to the officer that I assaulted, I would say that I'm sorry and I apologize for doing that.
Thank you. Thank you very much. Anything else?
That's it.
All right, Miss Underwood, is there anything you'd like to say on behalf of Mr. Bomarito?
Just that Mr. Bomarito has expressed genuine remorse to me, Your Honor. He understands that his problems that day, he didn't need to visit on the officer. Mr. Bomarito is in prison for a long time, Your Honor. He understands that. It's my hope that programming for Mr. Bomarito, I understand sometimes when people are in prison for a long stretch, Your Honor, they don't produce programming for them until it's like right before they're supposed to get out. It's my hope that Mr. Bomarito can get programming, Your Honor, and address issues, maybe educationally if he's able, and with his diagnosis, but just to ensure that Mr. Bomarito has the best chance for when he does get released, Your Honor. I believe Mr. Bomarito is sorry, and I believe the sentence that the court cobs to will be appropriate in this matter. Thank you, Your Honor.
Thank you. All right, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. The sentence of the court that you will serve 10 months to 7 years, 6 months with the Michigan Department of Corrections. Because you're currently incarcerated, you don't get any credit for time served. There's $130 crime victim rights fee and $68 in state costs. Now, Mr. Bomarito, you do have the right to appeal the sentence, and we are going to mail out to you your notice of right to appellate review. One copy is for you to initial and date and send back to us to acknowledge that you received the paperwork. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right, Mr. Bomarito?
Your Honor.
All right, thank you so much, Judge.
Mr. Moore?
Yeah, could we address the consecutive sentencing, please?
And it's consecutive to that, current sentence you're serving now on homicide and felony firearm. Are you still serving the felony firearm? Or are you done with that one now, Mr. Bomarito?
I'm done with that.
All right, so you're on the homicide one, so it's consecutive to that one, okay, Mr. Bomarito?
Okay, thank you, Your Honor.
Thank you, and you have a good day.
So, thank you, Ms.
Bye-bye.
Underwood.
Good luck, Mr. Bomarito.
All right.
Okay, so, do you want to go sit with your attorney? So this is in the matter of the people of the state of Michigan versus Castro Cash Oliveras. We have two files, 24-21891FH and 24-21892FC. I have Dave McCready appearing on behalf of the people, and I have Michael Dagger Margosian appearing on behalf of Mr. Oliveras. This is the date and time set for sentencing. Mr. Oliveras, have you had a chance to read and review the pre-sentence report?
Yes, I have.
Have you had an opportunity, Mr. Dagger Margosian, the microphone? Yeah. Mr. Dagger Margosian, have you had an opportunity to discuss it with Mr. Dagger Margosian?
Yes, I have.
Are you satisfied with him as your attorney and the advice that he has given you?
Yes, I'm satisfied.
All right, Mr. Dagger, first, Mr. McCready, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
There are a couple of things, Your Honor. And I've gone over these with Mr. Dagger Margosian. On the first page indicates that there's a plea agreement of home invasion third degree. In the body of the report, it's correct in a second degree, but that should be changed.
Okay, so under the box where it says plea agreement, it's second degree, not third degree.
Correct.
Okay,
Second page. Again, under home invasion second degree, under the boxes. Again, the recommendation of 2 years to 15 years, that's fine. I just want to note that there's a Killebrew that covers both files. That is a 6-year to 15-year sentence. But more critically, the victim in that case.
can we go by file number? So 24-21891FH is a victim.
Correct. The victim on 891FH is Juan Sanchez, not Troy Pasha.
Okay, hold on 1 second. And it's Juan Sanchez.
Correct.
All right, so we will strike Troy Pasha and put in Juan Sanchez. Is Troy Pasha the victim on the second one?
That is correct.
Oh, okay, got it. Thank you.
Then there's one scoring error on the sentence information report. Do you want to cover that now or?
Yeah, we're going over, are you talking about guidelines?
Yes.
Oh, we're not at guidelines yet. Okay, would you agree with all those changes that we've made, Mr. Dagger Margosian?
No objection.
All right. Do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Nothing in the body of the report.
All right. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect, Mr. McCready?
No.
And Mr. Dagger Margosian?
None to my knowledge at this time.
So now I'm gonna go back to the guidelines. And is it both guidelines or just one of them?
Just one, just the 892 FC case.
Okay, so the guidelines were computed, PRVs were 25, OBs were 50, and 108 to 180. So are you disputing a PRV or an OB?
OB.
Which one?
OB6.
OB6. OB6 is currently scored at 10. And what are you saying it should be properly scored at?
It should be 25. He's pled guilty to intent or no contest to assault with intent to murder. 25 points is scored when there's an intent to kill, non-premeditated intent to kill.
Do you oppose or agree?
Your Honor, based on the plea itself and based on the fact that there is a sentencing agreement, I don't have a challenge at this time.
Okay, so I'm going to change OB6 to 25, which will make the total OB 65. Does that change the
Makes the OB level 4.
Okay, and what about the minimum range?
Range changes to 126 to 210.
And no position then, Mr. Dagmar goes in.
I agree with that change. That's changed, guys.
Okay, thanks. All right. Okay, so, all right, so we will make those changes. Before the court passes sentence, Mr. McCready, is there anyone here that wishes to speak as a victim?
I don't think so.
Okay, before the court passes sentence, is there anything you'd like to say on behalf of the people?
Just that we'd ask that Your Honor to follow the sentencing agreement that we've reached.
All right, and the sentencing agreement of 6 years to 15 years, that does fall within the sentencing range, so it would not be his guidelines.
Sorry. It is not, it is outside the guidelines for the home invasion, but I will indicate that he was initially charged with home invasion first, and it is within the guidelines for the home invasion first. He was getting the benefit of the bargain.
All right, and is that part of the plea and part of the bargain? So the people, you have no objection on any exceeding of the guidelines on that count?
On the departure, correct.
Okay, all right. All right, anything else you wish to say on behalf of the people?
Just that part of the agreement was that there was restitution as determined by the court, and I do know that there is restitution because the stabbing victim, Troy Pasha, has contacted us with his medical bills, but our victim services did ask him to bring those in, and he hasn't yet, so I don't know how the court wants to deal with that.
So we can leave restitution and be determined, but obviously he will have an opportunity to have a hearing on that restitution. Mr. Dagmar goes in, any objection to that?
No.
Because he would have a right to contest.
Okay.
Okay. All right, anything Mr. Dagmar goes in you'd like to say on behalf of your client?
Your Honor, I would just ask the court to follow the sentencing agreement. I will say that while the 6 years is outside of the newly calculated guidelines, it really, and this is what I would have argued at if this was litigated, is that that range does fall within what would have been a GBH sentence, and that's what I would have argued at trial. And so that's just sort of the nuts and bolts on how we got to that sentencing agreement. As always, when a person is charged with an offense, there's always kind of more to the story than just what's on the complaint sheet. In the stabbing incident, Mr. Olivares's infant was not directly involved, but Mr. Olivares was holding the child at the time of when there was this initial confrontation. And so the only reason I'm saying that is, again, there's always more to the story than just what is on the complaint. It doesn't excuse any conduct on Mr. Olivares' behalf, but I did just want to highlight that there was prior familiarity with the victims here. As far as the restitution, we can leave that to another day, but obviously nothing has been provided to the court or to people, so there's been not anything to address there. And then sort of moving to Mr. Olivares, I think the end sentence allows him, and he's young enough to, when he does get out of prison, to kind of turn this around and hopefully not be back in the criminal justice system. And I've talked with Mr. Olivares. He recognizes that obviously is the goal in life. And so I hope that after this sentence, he will better. And again, he's young enough to make that decision for his own. So that's all I have. I don't know if he wants to address the court.
Mr. Olivares, is there anything you'd like to say on your own behalf?
No, there isn't, Your Honor, but I thank you for this opportunity to get a second chance at life.
I hope you do, because you're young, you're 22. So you're very young. You're 22 still, right?
Yeah.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offenses, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentences are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for the law, and the protection of society. On file number 24-21891FH, sentence of the court that you will serve 6 years to 15 years with the Michigan Department of Corrections. You do have credit for 361 days already served. This hasn't been adjourned, right? No. During that term of probation or during that term of incarceration, you are not to have any verbal, written, electronic, or physical contact with Juan Sanchez directly or through another person. Once you're on parole, you can't be near the residence, school, or place of employment. There's a crime victim assessment fee in the amount of $130 and $68 in state costs. They probably will take that out like of your money account at MDOC. So if your family pays that up front, then they won't do that. On file number 24-21892FC, it's a sentence to the court. You'll serve 6 to 15 years with the Michigan Department of Corrections. You have 380 days credit on that file. You're not to have any contact with Troy Pasha, verbal, written, electronic, or physical, directly or through another person. Once you're on parole, you can't be within 500 feet of the residence, school, place of employment. $130 crime victim rights fee, $68 in state costs. Again, your family can pay that here, and that way it doesn't come out of your money at the MDOC. Restitution on that file will be to be determined. Once we receive that, you do have a right to have a hearing on it. And I believe you would still represent them on that as well, Mr. Degemer-Gozan. And those sentences run concurrent, so they don't stack. You'll be eligible for parole when you're 28 years old, so you'll still be young. Mr. Oliveras, there are services available within the Michigan Department of Corrections, educational, trade, whatever, your family's here. I'm assuming this is your family. I think you have support, and I think you can change this path. All right. So you do have the right to appeal these sentences. My bailiff is going to hand down to you what is called your notice of right to appellate review. You're going to initial 1 copy for each file for our records, just to acknowledge you received the paperwork. If you wish to appeal your sentence, you would fill out the information on the forms and mail them to the address listed on the form within 42 days. You can do that today, or you can do it once you get to MDOC. Is there anything I'm missing, Mr. Moore? All right, the record should reflect I received back the signed copies and the notice of right to appellate review. Good luck to you, Mr. Castro. All right, so this is in the matter of the people of the state of Michigan versus Benjamin Lee Likens. We have 3 files, 23-21610FH, 23-21611FH, and 24-21736FH. So, Mr. Likens, we are here for 2 things today. One is a probation violation on each file, and the second one is a contempt of court on each file for failure to appear for a probation violation show cause. So, the probation violations that are alleged against you is that on August 1 of 24, you were ordered to comply with recovery court. It's alleged that you failed to report for recovery court on May 22nd of 2025. You also stopped drug testing from May 22nd of 25 until May 30th of 2025. You then were compliant with 2 tests, then stopped testing again on June 5 of 25 or any time thereafter. And then again, missed recovery court on June 5 of 2025. For the record, we had recovery court on June 26 of 25, and he was also not present. The second allegation against you is that you were ordered not to use any illegal controlled substances, and you tested positive, on June 2nd of 2025 and admitted to the use of cocaine. So these are technical probation violations, and they're on each file. On file number 23-21610FH, You're currently on probation for possession of methamphetamine. So if you plead guilty or found guilty, the maximum penalty can be up to 2 years in prison. On file number 23-21611FH, currently on probation for possession of cocaine less than 25 grams. That carries a maximum penalty of up to 4 years in prison. On file number 24-21736FH, you're on probation for possession of methamphetamine. Again, that's a 10-year felony, right, Mr. Moore?
Yes.
And then possession of cocaine is a 4-year, and then another count of possession of cocaine. So on that file, you could be facing a maximum penalty of up to 10 years, 4 years, and 4 years. And that's if you plead guilty or found guilty of any of these probation violations. Then on each of those files is a contempt of court because the show cause was sent out for you to appear on June 18th of 25 for arraignment on that, and you failed to appear on June 18th of 25 for arraignment on the probation violations, and that contempt of court carries a maximum penalty of up to 93 days in jail. So, Mr. Likens, you do have a right to have an attorney represent you on these and all subsequent, with these charges, this hearing, and all subsequent hearings. If you'd like to, obviously you can hire one, but if you can't afford to hire one, we can appoint you one at public expense. Would you like an attorney appointed to represent you?
Yes, Your Honor.
All right, so I have Miss Underwood here today. So I am going to open up a breakout room for you, Miss Underwood. And I don't know what my breakout rooms are. There they are. So Mr. Likens, you're on a Polycom, so that'll take you automatically to the breakout room. Oh, we're back. All right. So Miss Underwood, have you had ample time now to speak with Mr. Likens?
I have, Your Honor.
All right. And Mr. Likens, you've had an opportunity to speak with Miss Underwood now?
Yes, Your Honor.
Are you satisfied with Miss Underwood as your attorney and the advice that she has given you?
Yes, ma'am.
All right, Miss Underwood, how would you like to proceed with both the violation of probations and the contempt of courts?
Your Honor, on the contempt, can we ask the address that was sent to?
It's homeless, because he's homeless, so I don't know, Mr. Moore?
Because he gave an address to the probation department.
I don't know, Mr. Moore, are you able, you're muted. Oh, I have 314 Elm Street.
513 East Front Street. That's my father's address. I guess I gave that to the probation department as soon as I was released out of jail on the 11th, or after my violation, previous violation for 11 days.
So your dad's address is, hold on, Mr. Likens, 314 Elm Street is your father's address?
No, my father's address is 513 East Front Street. 314 Elm is my previous apartment that I had. That I had surrendered the keys to so that I could.
So, okay, thank you. Mr. Moore, did he change his address?
Well, I do recall now, when speaking with him, that he was going to his father's address, correct? And however, I would question, was he there during this time, because his father doesn't put up with his behavior. So whether he was at that address when, and whether this was sent there or not, I don't know where Agent Tusky sent the
All right, so I'll dismiss the contempt of courts, but Ms. Underwood will proceed with the request and summons for probation violation. I've already arraigned him. So Ms. Underwood, how does your client wish to proceed?
It is my client's intention to take responsibility for this violation, Your Honor, and plead guilty.
All right, Mr. Likens, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right, so Mr. Likens, I asked you this already, but you've had ample time to speak with your attorney, correct?
Yes, ma'am.
Do you understand that you have a right to contest this violation of probation charge and to have a trial on it? Do you understand that?
Yes, Your Honor.
Do you understand that throughout this trial, you will be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes, Your Honor.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at the trial. Do you understand all of that?
Yes, ma'am.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, Your Honor, I do.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes, Your Honor.
I plead to the charge that you violated the terms of your probation by failing to report to recovery court and drug testing. Well, how do you plead to failing to report to recovery court on June 5, May 22nd, and then also failure to drug test from May 22nd until May 30th? Or June 5 or anytime thereafter? Say it again.
I plead guilty to all of the above, Your Honor.
Okay, and how do you plead to the charge that you violated the terms of your probation by testing positive on June 2nd to cocaine? Guilty or not guilty?
I guess I handed that sent out to the lab. I never found out about the lab results because it was, the preliminary test was positive. I don't know if the secondary test was.
My notes say that you admitted my notes say that you admitted to using cocaine.
Okay, I'll plead guilty to that, Your Honor.
Mr. Moore, can you verify whether the drug screen was sent off to the lab?
Well, if he requested it, it would have been. I would have to give me a second here and see if they, because I think I have an email here of our latest. But I would, let's see, give me 1 second. For some reason on the attachments, they don't have his on here, but I could find that out if he would know best because they will send it in if he requested it. But I mean, Ben, you either did it or you didn't, right?
There was a fog, like I said. I went on a drunk for a couple of days after a bad break.
So, Mr. Likens, did you or didn't you not admit to using cocaine?
I admitted to it, yes. I admitted to it.
Okay. Okay, so you'll plead guilty to that then?
Yes, Your Honor. Even though it's not of my norm, I will plead guilty. I just want you to think that that's something that I partake in. That's right.
Okay. Do you understand by pleading guilty, you'll be giving up your right to a trial, as I've already explained to you?
Yes, Your Honor.
Has anything been promised to you to get you to plead guilty?
No, ma'am.
Has anyone threatened you in any way to get you to plead guilty?
No, ma'am.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty?
Yes, ma'am.
Okay, so Ms. Underwood, I just want to say that the closed captioning is not always correct. I have found that the closed captioning here is often not correct. So for the record, Mr. Likens did not call me darling. He said, Your Honor. All right, because he would never do that. He's polite. All right. So, Mr. Likens, you were ordered into the recovery court program in order to comply with all the terms. One of the terms is that you had to report both to the Thursday recovery court meetings as well as report day with Ms. Teskey. Is that correct?
Yes, Your Honor.
All right, and you also were ordered to test as required through the probation department, correct?
That's correct, Your Honor.
All right, so did you report for recovery court on May 22nd?
To the best of my knowledge, no, I did not. Okay, I don't
Did you
remember the
report
exact date.
Did you report on May or on June 5th?
To To recovery court? I don't believe so, no.
Okay. And then you stopped drug testing from May 22nd until May 30th. Is that correct?
That's correct, Your Honor.
And then you tested a couple times and then you stopped testing again on June 5. Is that correct?
Yes.
Now, one of the terms, obviously, of recovery court is not to use any controlled substances. And you did test positive on June 2nd of 25 for cocaine, and you admitted to using. Is that correct?
Yes, Your Honor.
Now, you also said you kind of went on a binge. Were you drinking as well?
Your Honor, that's my substance of choice, yes.
Okay, all right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to refer this matter to the probation department for a pre-sentence investigation. Ms. Adams, what date are we using for this?
Judge, July 11th at 8:15.
So we will set this for sentencing on July 11 at 8:15 in the morning. Do you want to appear via Zoom or in person, Mr. Likens?
I would like to be in person, Your Honor, please.
Okay. All right. And so Mr. Moore is covering for Ms. Teskey right now, so he'll come over, talk to you via Zoom, and he'll do an updated probation violation report. We'll get a copy of that to Ms. Underwood, and then Ms. Underwood will review that with you. She's really good about reviewing it in advance. We will see you back July 11 in person at 8:15 for sentencing. Anything else?
Your Honor, can I have a breakout
Yes.
room with them? Do we have time for me to?
Yeah,
have a
yeah, you
breakout
can.
room?
Miss Adams, what were you gonna ask?
The bond was only on the contempt, so I didn't know if you wanted to address what the bond would be.
Yep, I'll set a $500 bond on each file for the probation violation.
Is that cash?
It could be, yeah. All right.
Your Honor,
Yes.
I know recovery court is especially cognizant of relapses and getting people the help they need for those, Your Honor. And I'm hoping that should treatment be appropriate in this matter, that is not delayed in any way by a sentencing that's out a couple weeks.
I am gone next week, so if Mr. Moore decides that treatment is available, he can address that with Judge Olsaver and have him sign it. But we will be back July 11th.
We will go on the record in the matter 25 CF42, State of Wisconsin versus Stephanie Achterling. The state appears through District Attorney Kevin Schmidt in person. We have Charlene Perrin appearing by video conferencing with approval of the court. Ms. Achterling is not appearing, at least at this time. She has the ability to appear. This is a status, so her appearance is not necessary. She is still in custody. We had a very lengthy domestic abuse injunction hearing that went far beyond the time scheduled. And so we are running a little bit delayed. And so I am also delayed in my 11 o'clock case. So I'm moving on right now. And since it is a status, again, Ms. Achterling's appearance is not required. Ms. Perrin, can you please update the court?
I did file a bond motion, Your Honor.
I have reviewed it, yes.
Okay, and we don't have any agreements at this point. We've gone back and forth a little bit with counter offers, but we don't have an agreement. So that's where we're at right now. So could we set a bond hearing? Or could I do
Yes.
that with your assistant?
I can set it right now. Can you do July 7th? By video is fine at 1:45.
I can't do it at 1:45. I could do it at 2 if the court had time.
It's literally my only time, but I guess I only have a status from 2 to 2:15. I can double it up, so I can do it at 2.
Okay, thank you.
All right, so we'll see you at 2 o'clock, July 7th. Thank you.
Thank you.
All right, now let me get all of my other information up and then we will be ready to go. We will go on the record in the matter 24 CF 143, State of Wisconsin versus Michael Winquist. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Winquist appearing in person in custody with counsel Eugene Harrington. We're set today in this matter for an oral ruling. The parties have requested that the court review and approve a plea bargain, a plea deal that has been presented. We are in victims' rights compliance.
Yes.
All right, we are in victims' rights compliance at this time. Although I'm going to be making an oral ruling right now, I'm only going to give you a gist or a brief summary of what my decision is. I have a full written decision that I will sign immediately after this hearing, and the parties will have access to. The reason why I am not going to submit it right now, or I'm not going to read the decision because it is 13 pages. So it gives much for the parties to review and to discuss, but I'm going to say this was a very difficult decision to make. I have in front of me allegations of very heinous crimes that cause significant and permanent physical and emotional harm to a person and left a juvenile emotionally scarred. I have 2 attorneys whom I respect thoroughly, who understand the law and know the facts of this case thoroughly, more thoroughly than I have been provided. I only have access to the facts in the criminal complaint, the statements made during the hearings by counsel, and the facts that as they are outlined in the defense's stipulated facts memorandum. A plea bargain requires a court to have thorough review of what it has in front of it. If a prosecuting attorney has agreed to seek a charge or sentence concessions, they must have the approval of the court, and the court must personally inform the defendant that the prosecutor's recommendations, that the recommendation, this joint plea bargain is not binding on the court. This bargain, this plea deal, must also be evaluated to ensure that it serves the public interest. The court's duty and role is to safeguard the public interest, to substantially ensure the benefits and the advantages to the public. Deciding whether to reject a plea agreement is firmly within this court's authority and discretion. It is vested in me, the judge, and the circuit court to determine what pleas do serve the public interest without allowing the court to interfere with the prosecutor's authority when the prosecutor decides what charges to file and whether to file charges at all initially. There are certain factors that a prosecutor considers when deciding whether to file charges, and these factors somewhat overlap with the court in determining public interest in whether to accept a plea. These include such things as extent of harm caused by the offense, threat posed by the public or to the public by the suspect, the ability and willingness of the victim to participate, the disproportion between the authorized punishment of the particular offense or the offender, possible improper motives of the complainant, cooperation of the suspect defendant with the arrest and prosecution, the possibility of a likelihood of prosecution by another jurisdiction. That doesn't affect our case. Accordingly, these factors that a court must weigh when defining a public interest and what interest is involved, it varies from case to case. I must look at each of the facts and look at each of the cases separately. One appropriate factor for one case may not be something considered in another case. Things that the court looks at and reviews would be such things as viewpoint from law enforcement officers, as well as other things, which it's not an exhaustive list, but I must take into account the public's right to have crimes that are actually committed to be fairly prosecuted and to protect the rights of third persons. The court must evaluate the defense attorney's reasoning and arguments and recommendations and balance that with the public interest and with the prosecutor's arguments to seek a fair prosecution. Other components of a public interest that the court must consider include whether the defendant has voluntarily and intelligently entered into a plea agreement, plea bargain, whether a factual basis exists for a guilty plea, the general public's perception that crimes should be prosecuted, the interests of the victims, the court's ability to dispose of a case in a manner to commiserate with the seriousness of the criminal charges, and the character and the background of the defendant, and the plea's usefulness in securing a legitimate and important prosecutorial interest. It has been observed that there may be situations where the public interest might be better served by having a case tried rather than having it disposed of with a guilty plea. The court has reviewed the facts of this case, the information, the complaint, the transcript for the preliminary hearing, the defendant's admission of facts, and the defendant's memorandum regarding the public interest of the plea. I've also heard very thorough, thought out arguments by both attorneys and an impactful statement by the victim. The court wrestles with the notion of accepting a plea in totem. That means to accept the plea as it is fully presented to the court as a complete agreement. Standing alone amendment, and the amendment to count one may likely be appropriate and would meet the public interest consideration. The rest of the plea agreement causes skepticism and trepidation. The court has a responsibility under case law and its higher courts to reject a plea agreement that does not serve the public interest as a whole and not simply in parts. The plea agreement as extended and when compared to the allegations of the criminal conduct with the facts available to the court gives the court apprehension. What jumps out in the record is the nature of the facts within the criminal complaint and the preliminary hearing transcript regarding the specific allegations of the defendant's criminal thinking. His blatant, utter disregard for public safety, in addition to his complete and total disrespect for the law. There are situations, again, where the public interest is better served to have a case tried rather than accepting a guilty plea and disposing of a case if the plea agreement as a whole is not appropriate and does not meet the public interest. The essence of this case remain. The defendant was not legally allowed to consume alcohol due to being on active probation with an absolute sobriety condition. He frequently binges on alcoholic beverages and is often intoxicated. He cannot legally own or possess any firearm because he is a convicted felon. He either has been diagnosed with or shows symptoms of PTSD from his military service and other life traumas, and did not seek therapeutic or other medical services to address it. He is aware of, or should be aware of, his history of experiencing a sleepy, dreamlike state, which is unpredictable and has violent outbursts upon sudden awakening. And worst of all, he unlawfully keeps a loaded firearm next to his bed and throughout the house has multiple other firearms stashed away. And he is fully aware of all of the above. The defendant's knowledge of the above, combined with the defendant's intentional conduct and behavior of disregarding the law and violating probation conditions, not only puts the community at risk, but also creates a safety hazard with the potential for a significant probability of death or injury to himself or others. Taking all into account, combined with the victim's allegation of the shooting, the court is concerned that accepting the plea deal as it has been extended would convey an undesirable message to the public, suggesting that the conduct is not as horrific and gruesome as it may have been. The plea would lack the deterrent effect needed to prevent others from engaging in similar serious criminal conduct and behavior. The court need not accept the plea offer as presented unless the court is convinced that the state and the defense with certain facts exist. If the district attorney is publicly stating that the state cannot prove in a court of law beyond reasonable doubt that an impartial and unbiased jury of the defendant's peers would find the defendant engaged in allegations related with each, and I am specifically stating each charged account or any associated subsequent or lesser offense, that would be one thing. However, with this case, the attorneys are simply informing the court that considering the facts and the evidence, count 1, first-degree intentional homicide as an attempt, is not the accurate charge, as the evidence points to a lesser included charge, and a more appropriate charge would be, as the parties have agreed, second-degree reckless endangering the safety with use of a dangerous weapon modifier. And that may be accurate and true. The court notes that as the facts are outlined in the case, the modifier is, for the most part, meaningless and does not increase penalties, sanctions, or otherwise. Additionally, as part of the plea bargain, the defendant would plead guilty to only 1 count of felon in possession of a firearm. The remaining 6 Class G felonies for a felon possessing a firearm would be dismissed and read in, along with the other misdemeanor count for operating a firearm while intoxicated. Again, the attorneys are not telling the court that the other 7 criminal charges cannot be proven beyond a reasonable doubt, only that count 1 is not accurate and it is not the correct criminal charge based upon the facts and the evidence of the case. The maximum possible penalty the defendant would face with the plea deal would be 12.5 years of incarceration and 5 years of extended supervision. Even if the matter proceeds to a trial as it is charged, and if the defendant is found not guilty on count 1 as charged with no lesser includeds, if found guilty on the remaining counts and charges, the defendant would face a maximum possible penalty of 35 years and 9 months of initial incarceration with 35 years of extended supervision. This is a significant reduction in the incarceration length hanging over the defendant's head. The court is looking at all of the information and the arguments and hearing the impact of the victim and the impact of the juvenile victim. And in viewing the gravity of the offense, if the facts presented to the court are accurate and factual, this case is so serious and so severe that it would depreciate the seriousness of the offense and promote disrespect for the law if the court accepted the plea deal. Further, it would not promote a public interest or be a deterrent factor to others. Even though the defendant is making concessions to plead to a serious charge and is accepting responsibility for some of his conduct and actions, the plea would not have the deterrence effect to prevent others from engaging in similar criminal thinking and a total disrespect of the law and the entire criminal justice system. The defendant was not only on probation at the time of these actions, but was also being monitored by the law enforcement and by probation with certain conditions and mandates. The defendant knew what conditions he must follow and abide by. He knew he was a convicted felon who was legally forbidden from possessing any firearm for life for any reason, no matter the reason or the excuse. Bears, squirrels, protection from burglars, or zombies makes no difference. The defendant is a convicted felon and has no legal right to possess a firearm for life. He intentionally disregarded that prohibition and spat at the legal system, believing he was above the law and could do what he wanted as he wanted. What happened that day was one of the most serious crimes that could have happened in a situation like this. The only worse outcome would be if the victim had died. Even though the defendant accepts the offered plea deal and admits to guilt, or would admit to guilt, thus eliminating the need for a trial, that is not a decisive factor. The impact on the victim must be viewed as well. The victim in this case is not opposed to a trial. Even if the defendant can prepay $10,000 or more in cash towards restitution, or could pay all of the restitution off at once to the victim, it is not a conclusive factor for the court or the victim. All components of this deal show that the defendant is not accepting the plea deal and admitting to guilt to limit the victim from public scrutiny, embarrassment, or trauma. Rather, the defendant is accepting this plea deal and would be admitting to guilt for his benefit and gain, the reduction of incarceration exposure. The victim and her son expressed that they would rather go to trial and have a jury of their peers determine whether the defendant is guilty on all charges rather than the court accepting the plea deal. The victims, in theory, could be re-victimized if the court accepts the plea as proposed. The state and the defense argue that there is inadequate evidence to prove and support count one as charged. The court is not making that determination. The jury is an impartial and unbiased decision-making body. The jury will determine the credibility and the believability of the facts, testimony, and evidence presented at trial. The state could request of the court permission to amend and file an amended information. If the matter does proceed to trial, should the jury find the defendant not guilty on count one, attempted first-degree intentional homicide as charged, without a lesser included offense presented, the victim must abide by and accept the decision of the jury. Even count one, not part of the equation, there remains 7 additional counts in the information. There is a possibility that the jury could find the defendant guilty beyond a reasonable doubt with the remaining 7 counts, thus increasing the potential sentence exposure to the defendant, leaving the court with a sentence determination. So as I have tried to outline and identify, the court is not accepting the plea deal as proposed. The court would consider any additional plea deals if they are constructed and gathered, but at least at this time, it's not received. Mr. Schmidt.
I understand. Thank you.
Mr. Harrington.
Judge, I would request that the court reporter prepare a transcript to expedite the transcript. The court, I also, because this is dean appointment, request that the court authorize me to inquire of appellate counsel for the purposes of interlocutory appeal.
Must do that in writing, and the transcript's going to say pretty much a lot of what is in my written decision, but you'll get both.
I need both. I need it expedited because the time for the A request for interlocutory appeal is 10 days, if I recall correctly.
20.
10, 20, doesn't matter. It's a holiday week next week. And then one final question, as it relates to interlocutory appeal and the evaluation of that as an option to the defendant. Will the court permit second-degree reckless endangering safety with a firearm to be a lesser included offense to the count 1 as alleged in the information? It goes to a jury. Do we get to use that as a lesser included offense? Kind of a premature question, but
It could be a premature question, but I may not have been as specific in my statement to the attorneys. The attorneys know the facts better than this court. Attorneys know the facts more in and out than this court. And whether or not, as it relates to intentional homicide, even as an attempt, whether or not the facts would be applicable or they would be able to meet each of the elements of that crime. As I stated, the attorneys have reviewed this. The attorneys have determined that second-degree reckless with the modifier may be a more appropriate charge. The state can always amend the information or can be a part of a different plea agreement, plea deal with other things included. Count 1 was not the issue for the court.
that raises another issue that I may have to consider for an appeal, but I understand. Thank you, Judge.
We're totally fine going through with the trial with all 7 counts or all 8, 9 counts as they've been charged. And the court is simply saying the jury, the unbiased decision-making authority who determines credibility and believability of the facts, as well as the testimony of the witnesses, gets to determine whether or not count 1 through 9, they find beyond a reasonable doubt guilt. As far as this court's concerned, we have a jury trial for count 1 through 9.
When's our next status hearing, Judge?
Whenever we set it, we're going to set it right now. We have a final pretrial September 4th, jury trial in October. What are you looking for with regards to status? How far out? And again, the case law specifically says the court has discretion to reject a plea agreement as is, and I'm rejecting it, and we're going to trial.
I agree. That's what the law says, Judge.
What are you looking at? How far out?
Do you want to revisit this 17th, 18th of July? You and I will revisit before then, but
Why don't we talk after this hearing? I think you might have heard things from Judge that she didn't say.
And you're going to get my written decision right here that says everything that I said.
Sure.
Everything I said. All right. So I don't have the ability to do the 17th or the 18th, but
the next week of the 21st. Status, real short status.
real
We'll
short
We'll
status.
either come up with
I can
a new
I
deal
can
or-
probably fit a real short status somewhere in that week that you're asking, but I have to look very carefully because I'm supposed to have a trial, but it is going to be most likely gone and I have other things scheduled. I could do the 17th. I have only a couple hearings scheduled.
what time, Judge?
My one hearing's at 2. How about 1:30?
1:30 works.
1:30 on July 17th. And if you're requesting a transcript, it must be in writing to the court reporter.
I'll send you an email.
All right, anything further?
Not for me.
Mr. Harrington?
Thank you, Judge.
Thank you. We are adjourned.
This morning is Brandenburg versus Goff. We ready to go, Ms. Ellison?
We are, Your Honor. I was just bringing in the
gentleman that's in the Genesee County Jail.
All right. First matter is Brandenburg versus Goff. That's file number 09-13272-DS. We have Tyler Goff with us. Ms. Ellison, do you see Mr. Goff in the waiting room?
I do not have Mr. Goff available.
Your Honor, this hearing was adjourned from May 23rd in front of Your Honor. At the hearing, the defendant was to turn himself into the jail the same day by 6 p.m. Since that hearing, the friend of the court did receive information that he did not report to the Otsego County Jail. An ex parte was issued on May 27th with no bond and for the defendant to serve 7 days in jail. There's been no payment or contact since. We are just requesting to further address the non-compliance after his arrest or potentially amend the current bench warrant due to the support enforcement order that was done on April 14th. He was required to pay $500 monthly payments or a 7-day commitment to jail. There had been since then no payment in April, May, or June.
What is it specifically that you would want in an order from me?
To amend the days to serve from 7 days to 21, as to those have been the 3 months since that initial hearing.
So ordered.
Thank you.
Is the bench warrant still outstanding so that once he is found, he's going to be picked up?
Correct. We would just need to then amend it, probably have a signature. I'll find out as to how to do that and have that prepared for you to sign.
That sounds good. Thank you very much. All right, the next case on the docket is Stephanie Moore and Jeremy Carey. This file is 09-13285-DS, set for an order to show cause. Do we have parties in that matter?
I'm here, Your Honor, but I don't think he is.
Could you put it on your video, please, Ms. Moore?
Yes, I'm trying.
There you go. Thank you very much.
Yes.
All right. Has the friend of the court had any contact from Jeremy Carey?
Your Honor, no, we have not. We would request that to enforce the order that he failed to comply with, and then also to request an order on arrears of $310.
Like he was here previously and was found in contempt, forfeit his bond. He was to make payments of $643 and or serve 7 days in jail. I take it he's not made any payments?
Correct. And his current obligation is that $643, and the arrearage is $29,876.53.
And you're asking for how much each month towards arrears?
310. That's pursuant to the arrearage guidelines in the child support formula.
That's the 2%?
Yes, and there was a support recommendation that was completed and mailed out to both of the parties as ordered by the court on June 11th. An objection period is set to expire on July 3rd. The new recommendation is for the defendant to pay $636. That sum's composed of $621 for support and $15 for ordinary medical. So it would go from the $643 down to $636, and it would still be appropriate as to the ordered on arrear amount if that was to be ordered.
All right. Ms. Moore, have you had any contact from Mr. Carey about today's hearing?
I have not, no.
Have you received any support payments recently from him?
Just the bail or the bond that he posted.
But nothing new and nothing recently other than that bond payment?
Right, no.
All right. Ms. Kraus, go ahead and prepare a proposed order as you have recommended. I believe that that's appropriate. The ordered on arrears amount does meet with the statutory requirement for 2%. And I believe that the new amount, once the support period or the objection period has gone past, we can do that new amount as well. So go ahead and do that in our proposed order for me. Ms. Moore, if you do have contact from him, or if you do receive any payments from him, please let the friend of the court know that, all right?
I will.
All right, that's all for today then. Thank you very much.
Thank you.
And on the June matter, however, I'm going to honor and respect the child's wishes here and give no bond. As you have given, I think.
All right. Next matter we have is Alicia Cooper and Brian Morgan. I do see that Mr. Morgan is present from the Genesee County Jail. This is a show cause. Ms. Kraus, is this your matter?
This is.
Where do we stand on this case?
This is an arrears only case as of September of 2024 with a balance of $7,869.49. This hearing was adjourned from April 11th when the plaintiff failed to appear but was lodged in the Genesee County Jail since March 25th. I did make contact with the jail to have him appear today. We're just requesting maybe to find out a little bit more as to why he's incarcerated and potentially then address whatever's going on with the show cause today after that.
All right. Mr. Morgan, can you tell me how long you're going to be in the county jail and what you're in there for?
I
I'm in here for a couple reasons, but I should be out. Well, I'm supposed to be out already. I'm waiting for mental health rehab. So that could be any day. I really don't know. As far as arrears, I've actually got an attorney general case going on, but I need to know how they changed my daughter's last name, because I'm a little irritated about that and how that happened and why it happened and why should I even be obligated for these payments if they're going to go and change my daughter's last name.
Okay, Mr. Morgan, let me deal with one thing at a time. So how long have you been in the Genesee County Jail?
I've been in here about 3 months now.
All right, the reason I asked is if you're in for longer than 6 months, we can have support abated, that is taken off for a period of time. However, if you're less than that, then the support continues. So I wanted to find out if it was going to be reduced for the period of time that you're in there. When do you anticipate being released from the county jail?
Well, I'm going to be in here for probably about 6 months with incarceration and rehab and all that. So it's probably going to be 6, 7 months when it's all said and done.
There's a difference between incarceration and rehab. If you're incarcerated, the statute says that you're entitled to have the incarcerated for more than 6 months. The statute says that you're entitled to have your child support abated, or that is reduced to 0 during that period of time, but it does not cover rehabs.
Are you guys not aware of the Attorney General? Are you guys not aware of the Attorney General case going on right now with me?
We are aware of that, but we do not control that. We don't necessarily have access to that. So that's not this case. That's other cases that you have that the Attorney General is covering. So this is an addition to those.
I just paid $7,000.
To those cases, yes, but not to this case.
They're the same cases. It's the same case.
No, they are not. They're entirely different cases. And that's
both
why
my child support cases.
They are your child support cases, but that doesn't mean that they're the same case. This is
All right,
for a different child. All right. So Ms. Kraus, what is his arrears amount on this particular case?
This particular case is arrears only, so it's not currently charging. The amount is $7,869.47.
All right. Do you understand that, Mr. Morgan?
Yeah. Yep.
7869 owed, and it's not currently charging, but it's still going to be owed when you get out because it's not impacted by the Attorney General's case. It's a totally separate case. So when is your release date from the county jail?
I have no idea yet.
All right, Ms. Kraus, we may need to contact the county jail and find out from them what his release date, and they anticipate his release date is, and set a hearing shortly thereafter. Mr. Morgan, you mentioned going to rehab afterwards. Do you have a specific place that you're going to be going to rehab at?
Yeah, it's called New Pass in Flint.
And when do you anticipate going?
I've been accepted into Genesee County Mental Health Court, so I'm going to be doing that for the next 2 years. So I don't know what that entitles. So I might not be able to work for 2 years.
Well, we'll find out, and we want to work with you. That's why we're having this conversation right now. We want to make sure that we know what's going on with you so that we can make good decisions in this case as well. And we'd be happy to work with the mental health court down there on whether or not you can work and what circumstances that you have. So we're happy to do that. We just want to keep in the loop and be informed. When do you anticipate release to new paths?
It could be any day. Like I said, I think I'm waiting on a bed right now.
All right. Ms. Kraus, if you would also make contact with the Genesee County Mental Health Court and find out what his status there is and when they anticipate him having future hearings, or at least give them your information so they can contact you about future hearings so that we can keep in the loop on those things as well.
I know my sentencing hearing for mental health court is on July 22nd. I do know that.
All right. That's helpful. Thank you very much. Ms. Kraus, is there anything else that you can think of that we can do today?
No, just if for some reason he happens to be released, if he could reach out, if he's available, just so then we can track down as to what's going on if we're not able to get that information before his release.
Your Honor.
Mr. Morgan? Yes.
In regards to them changing my children's last name, I want to know how they did that and how they went about doing that and why I'm responsible if they're going to just go ahead and change my kid's last name on me with no, I mean, as far as I know, they did that illegally.
Who is they and which child had a name change?
It was Alex. It's my oldest daughter, Mackenzie. Her last name is Cooper now, and Alexia Cooper and Kevin Cooper are the ones who did that. And I believe it was fraudulently done.
Why do you believe it was fraudulently done?
How are they going to change my kid's name? In order to do that, you have to have a legal obligation of another adoption to that child. And I didn't give up my rights on that child.
All right. Ms. Kraus, is that the child that's involved in this particular case?
Let me look just a moment, Your Honor.
I believe it's Mackenzie in this case, right?
Correct.
Yes, Your Honor.
Is that the child that you're talking about, Mr. Morgan?
Yes, it is, Your Honor.
And what leads you to believe that her name is now Cooper?
They posted documents on Facebook, Your Honor, of the new birth certificate, which they didn't show the top of it though, because the top of it still shows my name. They just showed the new bottom of it with her name change on it. So I'd like to get to the bottom of this as soon as possible. I've been talking to lawyers down here and they told me that's illegal for them to do that unless I gave up my rights on my child or unless I gave up my rights and also she was adopted by another person.
All right, Mr. Morgan, have you contacted the probate court for Otsego County?
I have, Your Honor, and that was done under Judge Cooper, which he is no longer available. So now you took over his spot. So they told me I don't know what to do.
Well, when did you contact the court about the name change information?
This was a few months ago, Your Honor, before I was incarcerated. They told me they had signatures. That's why I'm kind of wondering what signatures they had because they didn't have my signature because I would never sign off on my children. So I'm thinking they done it fraudulently, like I said.
Well, did you send paperwork to the court or what did you do?
I got incarcerated right after the phone call, Your Honor, so I haven't been able to do much other, I'm incarcerated right now. So I was going to get on the ball as soon as I got out of here. So, but until then, I'd like definitely all my my child support payment stopped if that's the case. If they're gonna change my name, I mean, I don't think I should be obligated to pay for the child if my child's not even gonna have my same last name.
That doesn't change your obligation as a father. You can call the child whatever you want to call the child. You can call her Fred if you want to. That doesn't change your
Well,
obligation.
then as far as my understanding is you guys did it illegal and you guys will have a lawsuit on your hands.
I don't have any idea how it was done because the paperwork's not in front of me right now. I don't have that information available to me. So I don't know if it was legal, illegal, or what, but a change of a child's name does not change the obligation of the father to support the child. The child is still here. The child is still incurring costs. This child still has to have support. If you disagree with the name change, you can certainly file paperwork to see if that can be redone or undone. But that has nothing to do with the child support obligation.
Well, that's fine. I just think it's a little ridiculous.
Well, if you disagree with any of that, you have the right to file motions with the court, but that's paperwork that you need to do. You can't just come into court on a child support matter and start talking about something else without filing motions. Everybody's entitled to have that information ahead of time so that they can review it and find out for you. If you just make a claim in court on the record with no prior notice, nobody has the proper paperwork to be able to make a decision. Okay, so if
I'm sorry, go ahead.
If you want to do something about that, then you need to file a motion that says, I think that the name was changed illegally. And then the court can set a hearing date and everybody can show up and we can all know what we're talking about. If you want to challenge the child support obligation to say that the child now has a different name and I shouldn't have that child support, you need to file a motion so that everybody has notice ahead of time. And then we can show up in a court hearing and know what we're talking about. But if you just make an allegation on the record when no prior notice, nobody knows what to do. You understand what I'm saying?
Yes, sir. Also, these arrearages were caused from an incarceration back from 2021 when I was incarcerated in Otsego County Jail for a DUI. What do I do about that?
Same thing I just told you to do. You file a motion and you have it set for a hearing. And then we'll consider that. But until you file a motion, the court doesn't have any knowledge of what you want to do. Okay, and I can't just do it right now off the top of my head because I don't have that documentation in front of me. So I have to know ahead of time what it is that you want so that I can review it and make decisions about it. So if you think that you were incarcerated for longer than 6 months in the past, and that should have been taken off of your child support, then you need to make a motion and you need to provide documentation, that is paperwork that shows when and where you were incarcerated so that we can confirm that and then we can make a decision. Does that make sense?
Yes, sir.
All right. Do you have any other questions, Mr. Morgan?
No, Your Honor. That's it. Thank you.
All right. Ms. Kraus, anything else for today?
No, I do not believe so. Thank you.
All right. That's all for today then. Good luck to you, Mr. Morgan.
Thank you.
All right, the next matter is Devin Hildebrandt and Chelsea Brink. That's file 11-14050-DS. I do see Mr. Hildebrandt is here. Do we have Chelsea Brink with us?
Yes,
Could you put your video on, please, Ms. Brink?
I don't have that capability, sir.
Where are you at right now?
I'm here via phone.
Where are you physically located at right now?
The Comfort Inn and Suites. I got a room here last night. My dad gave me $1,000. Ouch.
What type of phone do you have that doesn't have video capability?
Galaxy something. It's an Android device.
All right, and you didn't download the Zoom app? You're just calling in?
No, I'm connected via phone. That's the best I can do, Your Honor.
All right. Ms. Kraus, is this your matter?
Yes, for this case with the Hildebrandt, yes.
All right. My order last time was that Ms. Brink submit documentation about job applications. She was supposed to do 10 job applications each week to the Otsego County Friend of the Court. Has she done that?
She has not. There was a voicemail that was left in regards to a couple concerns that were outside of employment issues that were outside the scope of Friend of the Court. That message was left for the other case manager.
That's the most untrue statement I've ever heard in my life. My voicemails
Ms.
were
Brink?
regarding job applications I submitted.
Ms. Brink, I will get to you in just a minute, but you don't get to just interrupt somebody else that's talking. I can't have a conversation with one person if somebody else is talking over that. You will have a chance
Well,
to
I'm
say
not
what
going
you
to
need
accept
to say.
lies about me.
Ma'am, you will have a chance to say what you want to say in a minute, but I need to talk to people in order, and it's not your turn. If you're going to do that in the future, I'm going to require you to be here in court. And if you're going to be here in court, you're going to behave yourself just like you would when you're on the phone. You understand that? All right, Ms. Kraus, go ahead.
Yeah.
As to the voicemail and the contents, it would be more appropriate to speak to the other case manager. Her obligation is $197. The arrears for this specific case is $10,604.42. The only payment that's been received was a payment in April and May. $100 was received, but $49.37 was distributed to this specific case each month.
All right, I do see Mr. Hildebrandt is here as well. Mr. Hildebrandt, have you received any child support payments from Ms. Brink?
No, sir.
When was the last time you did?
I want to say it was in May and it was like $45 or something.
All right.
I think I might have received 2 payments possibly. And
Same
that
ones
was,
that Ms. Kraus was just talking about?
yes, sir.
All right. All right, Ms. Brink, please tell me why you have not done the 10 applications per week and submitted them to the Friend of the Court.
I've been in the hospital for the last month. You ordered it.
I ordered you to be in the hospital for last month?
Yes. The police came to my house and said they had an order from you saying to go to the hospital. So I went to the hospital with them.
Which hospital did you go to?
Well, they took me to Otsego Memorial Hospital emergency room and then transported me to D6 at Munson in Traverse City after that.
When were you
So I've been in
released
the
from the
hospital
hospital?
for the entire month, but I did submit applications to a few places. I left a voicemail on Friend of the Court and the prosecuting attorney's voicemails saying that I did that. And I had a job interview at Taco Bell yesterday, but it's really just not. I'm in a ton of pain. I've been in 2 car accidents, and I'm homeless. So getting a job and making child support payments is not at the top of my priority list. Although I know it is at the top of yours because my children need support, but I just can't right now. And I apologize for that, but there's just really nothing I can do. I don't know what to do. Nowhere seems to be hiring. I'm doing the best I can, to be honest with you.
Ms. Brink, what were you in the hospital for?
I don't even know. You ordered me to go to get checked out. That's all I know. And they sent me to the mental health. I guess supposedly it's a mental health unit.
When
This
were
is
you
not the
released
first time it's been ordered.
When were you released from the hospital?
2 days ago. I'm going to Petoskey's Mary Margaret house today to sleep on their couch. That's the best they can do. I have nowhere to go. And if I do that, I'm gonna miss out on the Taco Bell job, but I don't know what to do. It's either that or sleep in my truck, and I can't keep sleeping in my truck.
Do you have a community mental health caseworker, Ms. Brink?
Supposedly, I don't know. They're not really doing their job, to be honest with you, but I have an appointment with community mental health, in I'm sorry, I'm having a hard time speaking because I'm hurting, but, in between 3 and 4 days from now, I have it on my discharge paperwork. If I looked at it, I can tell you the specific date. I think it's, I don't know. I think it's a Wednesday or a Thursday this coming week. But if I go to the Mary Margaret house, I'm going to miss that appointment. So I don't know what you want me to do. I can do either or, but I'm going to struggle if I sleep in my truck for the next week. Luckily I have gas for you, but
What I want you to do is contact community mental health, and if you need to change the appointment, you change the appointment, but you go to your appointment so they can help you find not only mental health treatment, but you can find housing. There's places in Otsego County that deal with people who have difficulty
there's
finding
not.
housing.
I've tried. United Way is closed, and that's the only place that helps with housing. NEMSCA doesn't help with housing, and that's it. There is nowhere in Otsego County that helps with housing. I've called all the numbers.
MDHHS helps with-
I even went to the Goodwill Inn in Traverse City, and they rejected me.
Because of your behaviors.
No, has nothing to do with that. My behavior is fine, sir. Sorry that you don't like it, but that's not the truth.
Ms. Brink, you need to stop when I start talking. MDHHS helps with housing all of the time. Have you made an application there?
Sir, I've made all the phone calls. They're not helping with housing. If you'd like me to prove it to you, I can give you the numbers and you can make the phone calls yourself. But they're not helping me with housing. Well, don't say something that's not true.
Ms. Brink, you still have a responsibility to apply for work, whether it's
I have,
or not.
and I am.
You have not, because you've not submitted those to the.
Yes, I have. I've
All
been
right,
in the
you're out.
hospital. What do you want me to do? You ordered me to go to the hospital. You can't have your cake and eat it too, sir. I'm sorry.
Chelsea,
and I don't care if you think
Chelsea.
I'm being rude right now, but that's the truth.
Yeah, you got, please watch.
We're good. We're good, Mr. Brown. Thank you, though. I appreciate that.
No, you need to let my attorney speak if he's going to defend me. That's his job. You ordered for him to represent me.
Ms. Brink, what he was going to do was tell you to be quiet, not me to be quiet.
No one needs to be quiet. There's no reason for that.
Ms. Brink, when
We're
did you
having
go
a conversation to figure this out. Maybe if you hadn't taken my kids from me in the first place, we wouldn't be in this situation. There was no reason
Ms.
for
Brink?
that either, to be perfectly honest with you.
When did
I'm
you
a
go
good
to the
mom.
hospital? When did you go to the hospital?
The first time I went to the hospital was June 2nd because I was so suicidal because I'm homeless that I wanted to literally kill myself. And they put me in Sheboygan Hospital for 2 weeks, let me out, sent me to CREW, which is, which I don't know what it stands for. I can't remember right now. Crisis Residential Unit in Gaylord. And then they wouldn't accept me back for some reason because they didn't like that I went outside. And they said I went next door. And really, the honest to God truth is that because I wouldn't answer all their nosy ass questions. And so I went there, not even for 24 hours. The cops came twice. The first set of cops left, had respect for me and left. The second set of cops didn't, handcuffed me, put me in the car, and took me to the hospital and said that they had a court order from you and that you wanted me to be checked out. And so they sent me to Munson. And I just got out 24 hours ago. So I'm sorry that I haven't put job applications in, but I'm in a ton of pain. And I will.
All right, good. We're going to adjourn this for a month. You're going to do the 2 applications a day, 10 applications a week to the friend of the court. We'll have another
I'll
hearing.
do as many as I can, but I'm not going to waste my gas when I'm not getting hired.
Ms. Brink, that's a court order. If you're not going to do a court's order, you're going to be in contempt of court.
Whatever.
All right, Ms. Kraus, would you please make sure that that's in the next court order? That's all for today then. Thank you very much. Ms. Brink, you have one more case, so you need to stay on the line until that case is called.
Your Honor, could you
It's the
repeat,
same fit.
could you repeat the
It's
amount
the
of job
exact same.
application?
Yeah, please mute Ms. Brink. All right, Ms. Kraus, the order is that we adjourn today's hearing 30 days and that she submit 2 applications per day or the equivalent of 10 applications per week, just like the previous order.
Thank you.
And then we'll simply have it reviewed in 30 days. All right. Thank you, Mr. Hildebrandt. That's all for you today. You're free to go.
Can we, I got a question, Your Honor.
Go ahead.
The last hearing that we had that I was not allowed in on, I know there was Miss Kraus brought up the fact that she had sold her home and that it just got overlooked in the last hearing. It was mentioned and then nothing else was said about it. She had plenty of income to pay a little bit of her child support or some of her child support when she sold her house for $30,000.
All right,
You know,
Ms. Kraus, do you have any other information about that?
Outside of, it wasn't at the last hearing. Unfortunately, I wasn't present for that. I believe the other case manager handled the Mays one, but in April, we did receive information. Let me just look at my last notes.
I don't recall that off the top of my head. That's why I'm asking.
I do remember there was conversation that we did have notification or we were able to see that that property was sold online, but we weren't able to find the amount. It was addressed, but I don't know exactly what had happened in regards to that.
All right, between yourself and the other case manager, would you assist me in trying to pull up some statistics or facts on that? Get me as much information as you can, and we'll review that again at the next court date.
Absolutely.
Thank you, Mr. Hildebrandt. We'll deal with that then. All right, sir?
Yes, sir.
And if you, Mr. Hildebrandt, if you have any other additional information, would you submit that to the friend of the court so that they can get that to me so that we can address it on the record?
Yeah, I feel that it's always been just a blatant refusal for her to even pay any amount of child support, especially if she was just gifted $1,000 from her father yesterday. Should we expect a little bit of a payment? I understand that she's homeless and all, but that's by her own free will. She's the one that sold the house that was paid for. It's not a pity party for Chelsea today. It's, you have an obligation, you have children, support your children.
Yep, I understand that. But today's not the day for me to do that because I don't have all that information in front of me and I'd like to have it before I make a decision. So we'll deal with it in 30 days. Thank you, sir.
Yes, sir. Thank you.
All right. All right, the next case is Stanley Huffman versus Danny Marcinkowski. That's file 17-16885-DP. We have either Ms. Marcinkowski or Ms.
I'm sorry, Mr. Hufflink, may I speak? This is Chelsea Brink again. You said to stay on the line and that I had to stay for the Mason case, but you've already moved on.
I'm calling another case and I'll call your case, your second case in just a minute, but it's not up yet. It's not its time yet. So you need to hold on until that case is called. All right, the next case is William Mason and Chelsea Brink, file 13-15199-DC. Ms. Brink, are you still with us?
Yes, I am, sir.
All right, thank you very much. I'm going to ask the friend of the court to update me on this particular case, and then I'll give you an opportunity to present your side if you wish. Go ahead, Ms. Spillane.
This matter was adjourned from May 30th, and similar to the last case, she was supposed to provide 10 job applications each week. Support obligation is $202 a month plus $50 ordered on arrears. Her current balance is sitting at $13,107.99. with the last payment received in May of $50.63.
All right.
I paid two payments of $100 each.
In April
And
and
like
May,
I said,
right?
I've been in the hospital
Yep, I remember that. Do you have any
and I'm
dollars?
homeless.
Do you have any dollars currently available to you to make child support payments?
No, I do not.
Did you receive, you mentioned receiving $1,000 from your dad?
I'm
Why
homeless,
is-
sir.
I'm sorry, I didn't hear that.
I'm homeless. I'm not
All right,
paying
but you-
child support when I'm homeless.
You have an
My kid's
obligation.
not
to pay child
homeless.
support.
He has clothing, food, toys, big screen TV, Xbox. He's got everything he needs. His dad does not ask me for money. I've called him, spoken with him twice, agreed to let me see him and talk to him. That still hasn't happened. Called him when I
Right.
got out of the hospital. He was one of my first calls. Didn't answer. Nothing needs to be paid. Technically, I don't even owe that because all of that happened when I was incarcerated for a year in the Otsego County Jail. So it needs to be remedied, to be honest with you.
Ms. Brink, did you sell your house in the last few months?
Yeah, and I was homeless, so most of my money went to hotel stays because my parents have dementia and can't understand that I'm homeless and need to move home.
How much did you receive from the sale of your home?
I don't remember.
Did you receive documents that told you how much you received?
No, I did
from the sale?
not. No, I did
find
not
that-
receive documents.
I find that hard to believe, ma'am, that you can sell a house. and
Well,
not
you
have
can if you want, but I did not receive documents.
Who did you sell the house to?
I don't know. It was a company.
Which real estate agency
And the
did
other
you use
reason
to
I
sell the
sold
home?
my house is because Brian Morgan, who you just spoke with a little bit ago, proposed to me when I was living at the sober living house getting treatment for alcoholism. And he proposed to me, said to move down there, that he could get me a job at Lucky Steakhouse. Did not follow through on that. I got a job at Italia Gardens, and then they fired me. And I did make payments when I was working at Italia Gardens. They took it out of my paycheck. I didn't even receive a paycheck.
Ms. Brink, which real estate agency did you use to sell the house?
I don't remember. I think it was Smith Realty or something.
What did you do with the money
So
once
the
you
only
received
reason I
it?
sold my house is because I was cleared out in Davison with no money, no job, no vehicle, no support from my family, and I couldn't get back up north to take care of my house.
What was the address of your
I
house?
didn't want
that
to
you
sell it. I had no choice.
Ms. Brink, what was the address of the house that you sold?
1336 Girlsland Avenue.
And when was the sale?
I don't remember, May something or March. I'm sorry, March something.
March of this year?
Mm-hmm.
Do you recall who you sold it to?
No, I already answered that question once, Your Honor.
Your Honor,
Yes.
I just pulled it up on the county's equalization site. It shows that it sold March 25th for $37,000.
Thank you very much. I appreciate that. All right, Ms. Brink, I'm going to ask the friend of the court to prepare paperwork to send to you so that you can show cause as to why you've not made child support payments out of the funds that you received from the
I did. I
sale-
made two
sale
payments of
your home.
$100 each. It doesn't matter that I didn't pay the entire arrears. I made payments, period.
I'm going to ask the friend of the court to send me documentation of the information that they have about the house and about the money that you received from the house so I can determine whether or not you made sufficient payments towards your
No,
child
no,
support
no,
payments.
that's illegal. That's illegal. It doesn't matter that I didn't make the payments in full for the arrears. The state law says as long as you made an effort, and I did.
That's a good faith effort out of available resources is what the phrase is.
Yeah,
need
and
to
I
determine
did. That was all I could do.
Yeah.
By the time I got back up here to make payments, the money was damn near gone.
You'll have an opportunity to show me that at a future hearing, but I want you to have the
I don't have
information
receipts
about
for
that.
anything, so how am I going to show you that, Your Honor?
You're going to have to tell me about it then.
I just did tell you. Now you're just being facetious, rude.
All right. You'll receive
You shouldn't have to
documentation from
repeat
the friend of
yourself.
court.
You are an adult. You can hear me.
Ms. Brink, you're going to receive documentation from the friend of the court.
I have no
setting it
mailing
for
address,
hearing.
so I don't know how I'm going to receive documentation. You'll have to send it to my parents' house, and I'll be lucky to get it. Like I said, they have dementia. I'm trying to take care of them. Very difficult to take care of 2 children, 2 baby dads, because that's what they are. They're not grown men. They're little boys. Men do not ask women for money, to be honest with you. Not in the world I grew up in, and probably not in the world you grew up in either, Your Honor. And I have 2 parents that I'm trying to take care of that have dementia and diabetes, both of them.
All right, Ms. Brink, that has nothing to do with child support matters.
But
What we're gonna do is,
that's all circumstances that are related to it that need to be taken into consideration.
at the next hearing, you may be right, but not at today's hearing. So at the
I
next
am right,
hearing,
Your Honor. Obviously, I'm right if you're adjourning it.
no, I'm going to adjourn this for 30 days so that we can have a review of 2 things. One is going to be whether or not you owe additional money from the payment to your house. And the second thing is we're going to adjourn for 30 days so that now that you're out of the hospital, you can continue to make your 10 applications per week. So we'll have a hearing in 30 days on both of those issues. The friend of the court will send out a notice to you of the requirement to pay.
How are you going to do that, Your Honor? You do not have an address for me. I do not have an address. I am homeless.
Where do you want me to send it so that you get that information?
Well, I'll be lucky to get it. If you send it to my parents, they might communicate it to me over the phone, but that's the best I can do. And she doesn't understand that paperwork, so she's not going to really explain it to me very well.
Okay. Ms. Spillane, do you have Ms. Brink's phone number?
My phone will probably be turned off. I'm going to try and make my phone payment, but it's only going to be good for another month, maybe. Yes, they do have my current phone number.
All right. Ms. DeFider, can we schedule a hearing next month right now?
The best way to communicate is through my attorney.
Jenny would have to do that, sir, because I don't know what your schedule is like. So Jenny sets those dates.
All right.
So your
She's
your next motion day would be, what are we? Would be July 11th is your next motion day with us.
Let's set it for that at 9 o'clock.
July 11th at 9 o'clock.
Yep.
Let me write that down before we hang up. And is that just for bills?
That's for the 2 things that it's for both of these cases. So your case, with this case, which is with William Mason, and the other one is Devin Hildebrandt. Both of those cases will be set for 9 o'clock. The issues will be whether or not you've made sufficient payments out of the funds that you received, both from your father and from the sale of the house. if you disagree with that, you can file a motion. But I'm going to set it
I'm
for
not
that
going
kind
to be
of.
filing any motions because it doesn't need to be officially on paperwork, Your Honor. You're just being stupid now.
Ms. Brink, if you have an objection to what I'm doing, you must file a motion to object to it, or you can show up at the
Stop.
next hearing,
Just
make your
stop.
objection. All right. Ms. Blaine, is there anything else that we need to do today?
No, sir.
That's all for today then. Thank you very much. You're free to go, Ms.
Goodbye.
Brink.
I'll make
Thank
sure
you,
you're honored to schedule those and get those set on your docket so they don't get missed,
I
okay?
appreciate that. Thank you very much.
You're welcome.